let's discuss. We'll take like 5 questions. Yeah. Today also there was 5 questions only, no? You wrote? All of you? Illa. Others not writing. Wait, huh? Okay. State which of the following agreements are valid contract under Indian Contract Act 1872. They're asking which of the agreements are valid.
Sir, D.
Okay.
So first one is
A, who owns 2 cars, is selling red car to B. B thinks he is purchasing the black car.
sir, there is not concession ad either.
This can be answered in multiple ways. This can be considered as first one. There is no consensus ad item. That is the first question. First answer you can write. Next one is, I can also say the offer is not certain because I'm just saying that I want to sell a car. Which car I'm not sure. So the offer is also not certain. The third thing I can say, it can also be a case of bilateral mistake.
Mutual mistake.
The mutual mistake, the bilateral mistake. So whenever there is a bilateral mistake, so the answer can be written in any of these ways. Yeah, consensus ad item, mutual mistake, and what is that? No certain offer. All of this will come under the same genre only. So you can write answer under any of this. It is valid. If you get confused in any of these cases also, you can also write the given scenario comes under no consensus ad item, mutual mistake, as well as your offer. These things are same. Just like I had given you counter offer and unqualified acceptance, they also are same only, right? So you can always write both. Clear all of you? Yes? So is it a valid agreement? Answer is no. A threatened to shoot B if B does not lend him 2 lakh and B agreed to do it. Shoot. This can be considered as something which is forbidden or prohibited under IPC, and hence it is a coercion. So it is a voidable contract. A agrees to sell his house to B against 100 kgs of cocaine. Cocaine, unlawful. Lawful object, lawful consideration. I can consider this consideration as unlawful, and because of that the contract is void. A asks B if he wants to buy his bike for 50,000. B agrees to buy the bike. Is it a valid offer? Valid contract? Yes, it's a valid contract. Mr. X agrees to write a book with the publisher, but after a few days, X dies in an accident.
Void contract.
It's a void contract. When they made it, it was valid, but later on it became invalid. That's why we can call this as people void contract. When you made valid, later on invalid. Supervening impossibility, also considered as subsequent impossibility. When made valid, later on becomes void. So that's 1 mark each, and that's 5 marks for you. A enters into a contract with B that he sells his house for 10 lakh to B. Further, they both signed an agreement that if B uses the house for gambling purpose, then B shall pay 50,000 for it. B agreed to do this. However, after a year of sale, B started gambling business in that house. Can A claim 50,000 from B? Discuss with reference to the provisions of Indian Contract Act 1872. What is that they're telling you, people? A has agreed to sell his house to B for 10 lakh rupees. But people, if at all this house is used for gambling, then B has to pay another 50,000 rupees for it. That is what they're telling you. So if it is for, if you're using it for any purpose, then 10 lakh. If you're using for gambling purpose, then it is 10 lakh 50,000. Imagine like this. So I can say there are 2 contracts here. One is for other purpose 10 lakh. For gambling purpose 10 lakh 50. So what is the provision?
24.
The provision, forget section. What is the provision?
So part is legal.
Whenever there is a legal part, see, when you are using the house for any purpose that is legal, I am saying for 10 lakh you can use it for any purpose, and that has no problem in the law. Now whenever there is in a contract there are 2 parts which is separable, which is you can separable, non-separable. In this case it is separable. There are 2 different contracts. One is a legal part, one is a illegal part. The illegal part can be separate. Yes, sir. So this contract is different, this contract is different. This can be enforceable, this will not be enforceable by law. So unlawful part is void, which is legal is enforceable. That is my provision. Yes. Okay. That probably can be for 3 marks or 4 marks maximum. Seema was running a boutique in New Delhi. She has to deliver some cloth to her friend Kiran, who was putting up an exhibition at Mumbai. Seema delivered the sewing machine and some clothes to a railway company to be delivered at a place where the exhibition was to be held. Seema expected to earn an exceptional profit from the sales made at this exhibition. However, she did not bring this fact to the notice of the railway authorities. The goods were delivered at the place after the conclusion of the exhibition. On account of such breach of contract by railway authorities, can Seema recover the loss of profit under Indian Contract Act 1872? Understood the question now? Now in this case, what happened? You guys understood the question or not? Now what is the answer?
Section 53.
What, Ramana, what is the contract? Now leave section, tell me provision. Huh? Rajeshwari, what is the provision? Ganika, what is the provision? Then general damages. So remember people, in the given case, see, it is first of all damages. What has happened? One lady has sent sewing machine. It has to go through railway and it has to be delivered in New Delhi. Now what has happened? The day she has given to the railway authorities, she did not say anything. She just said the sewing machine has to be delivered to the other place. That's all. Now because of that, what happened people? The special circumstances are not communicated. That is, there is an exhibition, it has to be delivered within that. Nothing has been communicated. Now because of that, what people, whatever is naturally related to the contract, that is what you guys can calculate, or you can ask for compensation. So what you can claim is people, ordinary damages and special damages are not enforceable in the given case because the special circumstances are not communicated, and that is the scenario. Understood? So in this case, can she claim the damages, the profits? Answer is no. But is the railway authorities liable? Answer is yes. But whatever is naturally related to that, for that they will be liable, but not for the profit that she has lost. Agreed? Because it is not directly related to what they have not done. Agreed? Yes. See, whenever you are writing ordinary damages, this words has to be mandatorily there. What is that? Losses that naturally arise in the usual course of business. This is ordinary damages. This is the word. It should be there. Yeah, and whenever there is a special circumstance communicated, then you can claim for the special circumstance as well. Agreed? That becomes your special damages. Yes, okay. And any case law you can quote there? Hadley versus Baxendale. So if anyone who has written that also, you will definitely get an extra mark. Crankshaft. Abhimanyu, a businessman, lost his important documents at a crowded railway station. Ramesh, a passerby, voluntarily collected the documents and returned them safely to Abhimanyu without expecting any reward. A week later, impressed by Ramesh's honesty, Abhimanyu wrote and signed a promise to pay 50,000 as a reward. Later, Abhimanyu refused to pay, arguing that the act had already been performed voluntarily and therefore did not constitute a valid consideration. Ramesh filed a case claiming that the promise was binding. Decide under the Indian Contract Act whether Abhimanyu is liable to pay. Whether Abhimanyu is liable to pay? Why, Abbas?
Sir, no such that intention.
Liable to pay? What is this? This is nothing but people. Voluntary. Whenever you guys are doing anything voluntary. So if there is any voluntary services and if a person has promised to reward you for whatever you have delivered voluntarily, this will come under exceptions to quid pro quo, section 25. That is nothing but whenever I am writing what is that, quid pro quo. Now he is saying that this cannot be considered as a lawful consideration. Exceptions to quid pro quo says the rule of quid pro quo. Whenever there is a reward or any compensation that the party has promised for the voluntary services, it will be enforceable in the court of law. And hence, can I recover the money? Yes, I can recover the money. My provision, I need to write this. Yes, sir. And I have told you one more thing. Whichever question they are asking about consideration, just write off consideration definition. What is consideration? When at the desire of the promisor, promisee or any other person does promises. So write the entire thing and write down. Also, the rules of consideration says that what is that? A contract which is made for past voluntary services, compensation for past voluntary services is a legally enforceable contract. So on that, yes, I can exercise this contract. So I need to write that entire thing under provision. And then will come facts. Facts can be 1 or 2 lines, and conclusion will be same as it is. Ramesh filed a case claiming that promise was binding. Decide under the Indian Contract Act. Now we'll be writing it this way. See, every conclusion can be different. You can write that the contention of Ramesh is valid and the contract is binding the parties. And hence, Ramesh can enforce the contract and will be successful in claiming the compensation of 50,000, which was declared as a reward. Yes, that will be my conclusion. Clear, all of you? Yes. Okay. Because a businessman from Delhi entered into an agreement with Reddy, a trader from Hyderabad, to smuggle a large consignment of gold into India in violation of custom laws. As per the terms, Reddy would arrange the smuggling operation while Vikas promised to provide financial support and safe storage facilities. Both agreed to share the profits equally. The agreement also stated that Reddy would invest a portion of his profit in Vikas's legitimate textile business, which was a lawful activity. After the first successful operation, a dispute arose between the parties. Vikas received the smuggled gold but refused to share the profits, arguing that the agreement was unlawful. Reddy filed a suit for enforcement, claiming that at least the lawful portion of the agreement relating to the textile business should be upheld. Decide whether the agreement is enforceable under Indian Contract Act 1872. Enforceable? Why? What about this, that investment? Would invest a portion of his profit in Vikas's legitimate textile business, which is a lawful activity.
Binding contract also become void.
Any contract linked to illegal becomes what?
Become void.
Okay. You guys are saying any contract which is linked to illegality will also become void. Tacit is a silent contract. Huh? If separable. Okay. That is also one of the provision. One second. If separable and if it is non-separable. Okay. Why do you think that is the answer?
Because his whole contract was an unlawful contract.
Okay.
Money was
Okay, see, that's the main thing I'm trying to understand. Now you are saying agreement connected with illegal agreement. In the previous case also we saw, right? Unlawful in part and lawful in part. You guys said unlawful part is not enforceable and a contract which is lawful, that will be enforceable. You only said, right? So wouldn't the same answer apply here? No? Why?
Sir, because
What is the difference?
amount coming from the illegal
Profit. So there illegal thing.
profit,
The profit is coming from
illegal.
illegal activity. Okay. So, understood people, if you guys have understood the difference, the answer is that in the given case, what has happened, the entire contract is opposed to public policy, smuggling. Anything to do which is forbidden by law is considered as unlawful. So, it is an unlawful consideration and opposed to public policy. Agreed? Hello.
So in that question, there was no opposed to.
Now, I'll tell you the difference. See, gamble is one part. There, what happened? There were two contracts. One is if you use it for any purpose, you will give me 10 lakh. That's one contract. The another contract says, if you use it for gambling, you need to pay me 50,000. Can I say there are two different contracts? Now can I separate? This is a different contract, this is a different contract. Can I separate it easily? Now that's why what did we do? We exercised this. We did not exercise this because there are two different parts. You can split the contract itself into two. Now in this case what has happened? First you need to do smuggling. That's the primary activity. From this, if you derive any profits, that will be invested into textile business, which is legal. Now you tell me, how can I separate this? See, first of all, I need to get profits then. The profits are unlawful only. So because of that, this is not a separable contract. It is an inseparable contract. Because profits I need to make to invest it into the textile business. So if I take away profits, even profits is unlawful here. Then how will I be making profit to invest in textile business? Understood? So why did I tell you this is one of a tricky question? No? I would say 80% will be a failure rate in this particular question while you are attempting. Because it is tricky. Second thing, writing provision is the challenge. Few people will write it this way, few people will write it this way. Answer is simple. Anything to do which is forbidden under the law, I always tell you, it will be there in the question only. See, to smuggle a large consignment of gold into India in violation of custom laws. Anything which is forbidden under any law, if you enter into a contract to do that, it is considered as what? Unlawful. That's the provision. So writing the provision here is a little challenging to exactly get that point. Understood? All of you? That's the provision. So will I get it? Answer is no. You won't get it. It is not exercisable. The whole contract is unlawful and hence it is void. Understood? All of you? This can be asked for say 5 marks, 5 to 6 marks.